Speaker, I now move that we declare a privilege hour. So move, Speaker.
Is there any objection? There being none, motion is approved. Privilege hour is hereby declared. Floor leader.
To avail of the privilege hour is the gentleman from the 2nd District of Oriental, Mindoro. I move that we recognize the Honorable Reynaldo Umali.
The Honorable Representative Reynaldo V. Umali of the 2nd District of Oriental, Mindoro is recognized to avail of the privilege hour. Please proceed.
Thank you, Mr. Speaker. Mr. Speaker and distinguished members of this august chamber, it was December 3, 2013, when I last delivered the privileged speech entitled "The Clear and Present Danger of Judicial Despotism," to address the issue of judicial tyranny. Today, I stand before you, my distinguished colleagues, to take another step in my advocacy for judicial reform, a fearless crusade that I have begun from the moment I assumed office as a neophyte congressman of the 15th Congress and have stayed faithful to until today. Let me recollect to you my arduous journey in furtherance of this crusade. In September 2010, I delivered my first privileged speech entitled "The Fallacy of Judicial Intervention in Impeachment Cases," in reaction to the TRO issued by the Supreme Court and joining the House Committee on Justice from hearing the Ombudsman Gutierrez impeachment complaint, because it has always been my position that impeachment cases are beyond the subject of judicial review. Rightly so, the High Court dismissed the petition for certiorari of former Ombudsman Gutierrez, an event that eventually paved the way for her resignation the following year and the needed reforms in the office of the Ombudsman. Presumably, the renewed trust and confidence in the Ombudsman is one of the reasons that emboldened Benhar Luy et al. And thereafter Ruby Tuason and Dennis Cunanan to come forward as state witnesses and or whistleblowers. In pursuit of my crusade, I prime moved two other impeachment cases which were initiated in the House of Representatives: the case of Associate Justice Mariano del Castillo for betrayal of public trust, and the landmark impeachment case against then Chief Justice Renato Corona, a case which is now immortalized in the pages of our history as the first instance of a successful removal from office of an impeachable government official with the help, of course, of the small lady. I thought this momentous event would also engineer the desired reforms and changes in the judiciary, but I was wrong. My dear colleagues, it seems that the road to judicial reform is a long and difficult one. The struggle is far from over. It appears that the remnants of the old ways remain in the halls of the Supreme Court, which continues to bully its co-equal branches of government. Although it holds neither the power of the purse nor the power to execute, the judiciary headed by the Supreme Court is now acting like three branches of government rolled into one, usurping the powers of its co-equal branches, the legislative and the executive. Let me enumerate the ways. In the case of Francisco versus House of Representatives, which involved the impeachment case against former Chief Justice Hilario Davide, the Supreme Court infringed on the impeachment powers of Congress in contravention of the latter's constitutional mandate as the body which has the sole power to hear and decide all impeachment cases filed against then Chief Justice Davide. Unfortunately, this august body allowed itself to be bullied by the judiciary. Thus, an unwarranted precedent of judicial bullying in impeachment cases was established, which gave birth to, borrowing the words of an illustrious lawyer, Attorney Estelito Mendoza, the amusing spectacle of persons waking up early to file an impeachment complaint in the House of Representatives to preclude the filing of an impeachment complaint within a period of 1 year thereafter. Second, expectedly, because of this incident on the Francisco case, history repeated itself when the Supreme Court, unmindful of the respect due a co-equal branch, railroaded the issuance of an en banc resolution directing the Committee on Justice of the House of Representatives to observe a status quo in the impeachment proceedings of Ombudsman Gutierrez, notwithstanding the fact that some justices had not even received a copy of the petition for certiorari, thereby infringing again upon the impeachment powers of Congress. Rightly so, the 15th Congress, of which I am a proud member, did not allow itself to be bullied. Rightly too, the certiorari petition of former Ombudsman Gutierrez was dismissed. Unfortunately, the High Court did not take the opportunity of resolving what Father Joaquin Bernas opined in his article entitled Echoes from the Corona Impeachment, which appeared in the 27 January 2014 issue of the Philippine Daily Inquirer, as the grand ambiguity in the apparent conflict between the expanded power of the Supreme Court in Article 8, Section 1, and the exclusive power of Senate in Article 11, Section 3.6. And like Father Bernas, I also do not believe that it would be in the best interest of the nation for the Supreme Court to initiate a head-on collision with the Senate. Corollarily, I have to disagree with the opinion of Senator Miriam Santiago that the High Court can revisit the Corona verdict on ground of extrinsic fraud, particularly the alleged bribery of senators, because the language of the Constitution is clear and unambiguous that the Senate has the sole power to hear and decide impeachment cases, which I repeat is beyond the power of judicial review. Stated differently, there is no ambiguity in the language of the Constitution pertaining to the sole power of Senate to hear and decide impeachment cases, and I cannot imagine any other interpretation without courting a constitutional crisis. Verily, it is imperative for the High Court to revisit the Francisco ruling to clarify once and for all the legal issue which falls squarely within the ambit of a political question defined in the leading case of Cañada versus Cuenco, and I quote, "The term political question connotes in legal parlance what it means in ordinary parlance, namely, a question of policy." In other words, in the language of Corpus Juris Secundum, it refers to those questions which, under the Constitution, are to be decided by the people in their sovereign capacity, or in regard to which full discretionary authority has been delegated to the legislature or the executive branch of government. It is not concerned with issues dependent upon the wisdom, not legality of a particular measure. Third, not content with its unwarranted intrusions on various HRET cases in the past, the High Court now continues with impunity to bully this august chamber by emasculating the constitutional mandate of the HRET in utter disrespect for the separate and independent power of Congress. The High Court in the Regina Ongsiako Reyes versus Comelec overturned the prevailing jurisprudence on HRET jurisdiction, unmindful of the legal absurdity it will create, as pointed out by one of its members, Mr. Justice Brion. Mr. Speaker, should we allow ourselves to be bullied anew? Shall we wait for the time when the High Court, in the guise of judicial review, will again dictate on who will sit as members of Congress, like how it is now happening when a petition for mandamus has been filed against our colleague, the Honorable Regina Reyes? Fourth, let us be reminded that the case of Belgica and Executive Secretary, the Supreme Court also emasculated, if not usurped, the prosecutorial powers of the Executive Department by directing all prosecuting organs of the government to investigate and accordingly prosecute all government officials and/or private individuals for possible criminal offenses related to the irregular, improper, and/or unlawful utilization of funds under the PDAF. This is not to mention the many other issues that fall within the ambit of political question that the High Court intruded into, such as I earlier mentioned, the Francisco case. And then finally, the High Court remains oblivious to the fact that while it recently declared unconstitutional the use and purpose of lump sum funds like the PDAF, Malampaya funds, and the Presidential Social Funds, the Chief Justice of the Supreme Court continuously administers, allocates, and disburses the Judicial Development Fund exclusively, which fund is not even recorded in or accounted for in the National Treasury. Is there a different standard of justice for the judiciary versus the legislative and the executive departments with respect to administration and/or disbursement of funds? Mr. Speaker, my colleagues, first and foremost, as duly elected representatives of the people, we have the responsibility to defend and uphold the fundamental laws of the land and to protect the rights of the people we represent. We cannot keep closing our eyes to the judiciary's tyrannical ways and allow our great institution to be bullied if no one else rises against these despotic ways of the justices of the Supreme Court. Then allow me, my colleagues, to champion this cause. Now, we are rich in contradicting jurisprudence because it seems that those sitting in the plush seats of the supposedly inviolable tribunal can bend the laws at their whim, hence the birth of the phrase flip-flopping decision. Mr. Speaker, this is very worrying because judicial flip-flopping has a serious cost. I do not merely speak in financial terms. I also am talking about its cost on fundamental principles of due process, of law and jurisprudence, for violating the doctrines of immutability of decisions, stare decisis, res judicata, for emasculating the powers of the HRET, and for infringing on the separate and independent powers of co-equal branches of government, which bears on the judicial and political system of the country. Yes, the judicial elasticity of the High Court takes a toll on the judicial system as well as the whole political system, as manifested in the constitutional dilemma the country is facing today. The Supreme Court is supposed to be the last bastion of justice. Its ideal role can be likened to a mother from a womb, from whom a wounded child can seek compassion and true justice. As the highest tribunal in the land, the Supreme Court should be the stronghold of integrity and impartiality. Yet, how can we trust a Supreme Court that changes its mind whenever such change appears to be convenient? How can we believe in a Supreme Court that cannot even make up its mind on a single issue? How can there be justice when the Supreme Court has a malleable concept of justice and fairness? And so today, I take another leap in my advocacy to reform the judiciary as I illustrate the many instances of judicial flip-flopping. Let me refresh you of my earlier privileged speech last December covering the unusual case of Congresswoman Regina Ongsiako Reyes, where the Supreme Court unwarrantably emasculated the power and jurisdiction of the HRET. Indubitably, it has created a legally absurd situation, as pointed out by Associate Justice Brion, in that the HRET cannot acquire jurisdiction until 12 noon of January 30, 2013. And yet, HRET rules require the filing of petition within 15 days from proclamation of candidates. And if I may add my own version of another legal absurdity resulting from the Reyes ruling, there is now created two classes of congressmen. Neophytes like Congresswoman Reyes, who is not a sitting member of the House because they can assume only at noontime of 30 June 2013, and a second-termer like me, who is a sitting member until June 30, 2013, because I am a member of the House. Interpreting the High Court's decision, therefore, the Reyes ruling will apply to first-termers and not to second or third-termers. Mind you, Mr. Speaker, these legal absurdities did not exist prior to the Reyes ruling. So as the saying goes, why fix it when it ain't broke? As a consequence of the foregoing legal absurdities, the High Court wreaks havoc not only on the justice system, but on the political system of the country. So I ask, Mr. Speaker and distinguished colleagues, is this not judicial legislation and a clear violation of the principle of separation of powers? Should we allow the powers of the HRET to be defined and limited by the Supreme Court as it sees fit? Unusual was how Justice Brion described this case, and reckless and an obvious rush to judgment in view of the gravity of the issues presented and the potential effect on jurisprudence was how he called the outright and immediate denial, that is within 18 days of the petition of Congresswoman Reyes. More, Justice Brion described the majority's ruling that the jurisdiction only begins after the candidate has assumed office on June 30 as a complete turnaround from the court's prevailing jurisprudence and constitutes a major retrogressive jurisprudential development. He also pointed out that the majority's ruling is contrary to HRET rules and would affect all future proclamations. To my mind, Mr. Speaker, said ruling smacks of clear favoritism and even cronyism. Indeed, the doctrine of immutability of judgment and stability of long-established and settled jurisprudence is in jeopardy. In fact, the House leadership is not now confronted with the amusing spectacle of a lawyer, of a former congressman, disrespecting this august chamber by issuing a demand letter dated January 20, 2014, entitled Final Notice and Demand to Vacate Office, and threatening to file criminal and administrative cases against a sitting member. Would you like that to happen to you? As you very well know, a great majority of the members of the House of Representatives, numbering 171, have signed House Resolution 597, entitled Urgent Resolution Reiterating Adherence to the Time-Honored Principle on the Exclusivity of Jurisdiction of the House of Representatives Electoral Tribunal over all contests relating to election, returns, and qualifications of its members, to preserve the integrity, dignity, and reputation of the House of Representatives and its members. How do we now reconcile the position of 171 members representing the great majority of this House versus the flip-flopping decision of the Supreme Court, which recognizes COMELEC jurisdiction instead, apparently to favor a kin of one of the sitting magistrates? Shall the court now cite in contempt of court 171 congressmen who disagree with the erroneous Supreme Court ruling? Constitutional dilemma or crisis? Yes, this is the cost of judicial bullying and elasticity. Mr. Speaker, distinguished colleagues, a recent development has further complicated this situation. A few days ago, I received information that former Representative Velasco has filed a petition for mandamus under Rule 65 with prayer for temporary restraining order and injunction, which seeks to compel the Speaker of the House, the Honorable Feliciano Belmonte, to administer the oath of office in his favor and to direct and command the Secretary General of the House of Representatives to remove the name of Representative Reyes from the roll of members and of the House of Representatives and register his name instead. Again, Why is it that the mandate of the High Court is implored on an issue which clearly falls within the jurisdiction of the constitutionally mandated HRET? And why should the High Court allow itself to be used by one litigant, a losing candidate at that, who happens to have a father in the same court, at the expense of a constitutional crisis and or risk of impeachment? Is the interest of one person more important than the interest of the country and of this institution? The petition directly accuses the Speaker of deliberately refusing to administer the oath in petitioner's favor, and the SecGen of refusing to register the name and delete the name of Representative Reyes in the roll of members, despite the ruling of the Supreme Court in the Reyes case. Petitioner thus charges Speaker Benmonte of unlawfully neglecting the performance of his ministerial duty to administer the oath of office in favor of Velasco, and unlawfully excluding Mr. Velasco from the enjoyment of the right to hold office. But how can the Speaker be accused of committing these unlawful acts when in fact there has been no writ of execution issued by the court in relation to the Reyes case? Since when has the Supreme Court decision per se become self-executory without need of remand to the court of origin for the issuance of the necessary writ of execution? And now, as basis for demand letter from a litigant, former Representative Velasco repeatedly referred to in his petition to the several letters he wrote the Speaker, the Secretary General, and even to Representative Reyes, imploring them to recognize his authority to sit in Representative Reyes' stead. Again, it must be pointed out that these letters are not official orders or writs from the appropriate court or tribunal. They have no legal or compelling effect. Would it not be tantamount to a brazen act of emasculation of the House of Representatives if we are to acknowledge mere letters to vacate from private counsels? Must we as a body be bullied by an ordinary man who seeks to compel us to act on the basis of his mere orders? Indeed, it makes me wonder what other bemusing spectacle will this august body be subjected to in the near future. Will our leadership be held liable for remaining steadfast in upholding our constitutional powers? Will the Velasco camp find a way via court order to send a sheriff of some deputized law enforcement official to bodily carry out of these halls a sitting member of the House? Surely a full-blown constitutional crisis will ensue at a huge cost to our political system on account of a flip-flopping, albeit unwarranted decision of the High Court to favor a son of a sitting magistrate, which I submit constitutes betrayal of public trust, a clear ground for impeachment. Thus, I am in a quandary as to why a former Chief Justice of the High Court can find nothing questionable about the Reyes decision. I am referring to former Chief Justice Panganiban, who in his newspaper column entitled Disagree But Not Disobey, which appeared in January 26, 2014, issue of Philippine Daily Inquirer, defended the recent decision of the Supreme Court and even belittled the concerns of the House by asking why such a decision that in effect emasculated the HRET ignited a congressional conflagration, suggesting that we can only disagree with the Supreme Court's decision but never disobey. After all, we can always impeach the magistrates. Yes, I agree that we could only disagree but never disobey decisions of the High Court, no matter how erroneous, that Congress is not helpless because we have the power to impeach justices. My question, however, is why must we wait until we reach the point of filing an impeachment complaint against sitting justices? Impeachment is an ordinary remedy intended by the Constitution to be a last resort to remove incorrigible and erring impeachable officials, including justices of the Supreme Court. To my mind, the best working democratic government is one where people are satisfied because problems are addressed at the earliest possible time, thus averting a constitutional dilemma and or public restiveness and or calls for civil disobedience. It is in this light that I hope our criticisms and calls for action are taken. Further, I find it difficult to understand how the former Chief Justice can be so cavalier about flip-flopping decisions of the court, which has happened too many times in the past to go unremarked. While justices may err and not be impeached for their errors, they also cannot whimsically and capriciously flip-flop to the point of violating established principles of law and jurisprudence and of due process and infringe on the doctrine of separation of powers, thereby fomenting a possible constitutional crisis. Be it remembered that when a Supreme Court errs, this error becomes part of the law of the land, even if it diminishes the powers of co-equal branches of government, just like what had happened in the Francisco ruling and in the various HRET cases, including the Reyes ruling, which was unwarrantably intruded into by the High Court. Therefore, justices must be the embodiment of justice and fairness, and their reputations ought to be free from even the mere appearance of partiality and moral corruption. This is the essence of my advocacy for judicial reforms. Mr. Speaker and distinguished colleagues, we have seen other instances of judicial fickle-mindedness and elasticity in the cases of League of Cities versus Comelec, wherein the High Court reversed its previous ruling declaring the cityhood bills of 16 municipalities as invalid and unconstitutional, and eventually ruling the same cityhood bills as valid and constitutional, notwithstanding the underlying inconsistency of such bills in the local government code prevailing at the time. The Supreme Court in this case reversed itself 3 times before finally deciding to uphold the validity of the cityhood bills, even if it is contrary to the provisions of the local government code. Thus, Mr. Justice Antonio Carpio succinctly stated in his dissent that the SC decision declaring the 16 cityhood laws unconstitutional had already become final, particularly after the denial of 2 motions for reconsiderations filed by the 16 municipalities. He also pointed out that not only was an entry of judgment made on May 21, 2009, the decision was already executed when the Department of Budget and Management issued Local Budget Memorandum Number 61 on 30 August 2009, providing for the final internal revenue allotment for 2009 due to the reversion of the 16 newly created cities. In addition, Mr. Justice Carpio also noted that 14 congressmen having jurisdiction over the 16 respondent municipalities at that time filed House Bill 6303 seeking to amend Section 450 of the Local Government Code as amended by RA 9009. The proposed amendment was intended to correct the infirmities in the cityhood laws as cited in the Supreme Court in its 18 November 2008 decision. However, to the surprise and alarm of the legal community and the public in general, the court reopened the case despite its finality and rendered 3 more decisions, 3 reversals in a row. 21 December 2009 declaring cityhood laws constitutional, 24 August 2010 declaring the cityhood laws unconstitutional, and lastly, on 15 February 2011, declaring the cityhood laws constitutional. Clearly, there were 3 reversals or flip-flopping in this case. Not surprisingly, then Associate, now Chief Justice Maria Lourdes Sereno, in her dissenting opinion, raised concerns over highly irregular and unprecedented acts of entertaining several motions for reconsiderations, as well as to the effects of the flip-flopping decisions on the court's role in our democratic system and its decision-making process. Thus, Madam Chief Justice distinctly warned that the public confusion sworn by the pendulum swing of the court's decision has yielded unpredictability in the judicial decision-making process and has spawned untold consequences upon the public's confidence and enduring stability of the rule of law in our jurisprudence. How this turn of events remains unexplained, how this turn of events happened remains unexplained to this very day. Even veteran litigators were shaking their heads in disbelief. Again, whispers circulated even in these August halls that ERAs or internal revenue allotments of local government units were set aside for purposes of ensuring victory of either side. Until today, what happened is still a mystery clouded in mist and ambiguity. So I urge again, small ladies or even small boys to heed to the President's call towards the Matuwid and come forward to unfold the mystery. I will protect your identity the way I did during the impeachment trial of Corona to the small lady. No wonder even one of the foremost legal luminaries in the country, Attorney Estelito Mendoza, in his letter to the undersigned, expresses concern over the League of Cities decision. He suggested that Congress needs to, and I quote, examine the power of the Supreme Court to declare laws unconstitutional and the way it has done so, as now reflected in the proceedings involving the constitutionality of the 16 cityhood laws. Enactment of laws is the principal function of the legislative department, more vital than its power of impeachment, when its authority to enact laws is undercut by an undue expansion of the power of judicial review that strikes at the very core of the function of the legislative department. Let me also illustrate the case of FASAP versus PAL, where the Supreme Court rendered the decision